Hey everyone, welcome to another episode of the Ask Amity Show. And today we want to talk about what to do when you have lost the copy of your trust or your will, or you just want to find someone else's trust or will. So lost trust documents or will are more common than you would think. The trust makers or grantors often serve as the original trustees and normally have possession of the original documents. However, when the grantor or the trust maker passes, what happens if no one can find that trust? The result is that there's no way of knowing who the decedent named as successor trustee, who they've named as beneficiary, or what the terms of the trust distributions are. In other instances, when the grantor moves or closes out their safety deposit box, the original document is lost. Sometimes the original document is accidentally or even intentionally destroyed, or the grantor can't find the living trust because they cannot remember where it has been stored.
So how can you request a copy? If you are the settlor or the grantor or the successor trustee, you may have some recourse. If you know the attorney that drafted the trust, you can contact them to request a copy. But if the attorney has since retired or has passed away, it may be difficult to find the location of the transferred files. When you establish a living trust, you need photocopies of certain documents to transfer some of your property, such as stocks, real property, into your trust. So you may be able to provide copies of your trust to your investment advisor, your tax preparer, or your accountant. So avoiding probate and keeping the terms of the living trust private are really two big reasons why people choose to create them. So you can't go to probate court to obtain a copy of the document.
So if you are the beneficiary and you are looking for the trust, you first need to determine whether or not the trust is irrevocable. So in California, a beneficiary only has the right to obtain a copy of the trust when their rights have vested. Their rights vest when the trust becomes irrevocable, which is usually upon the death of the grantor. The trustee is not required to provide a copy of the trust to the trust beneficiaries if the trust is revocable. By definition, a irrevocable trust can still be amended or canceled, which means a beneficiary can still be added or removed. Once you've determined that the trust is irrevocable and your rights have vested, then you can ask for a copy of the trust and you would ask the trustee. Usually the trustee would have a copy of the trust. More oftentimes, the trustee will gladly provide you a copy of the trust without any issues. However, if the trustee is unwilling to do so, and you know that the trust is irrevocable, then the trustee is legally required to provide a copy to all designated beneficiaries within 60 days, according to California Probate Code. This includes all trust documents, including any amendments. So you would send a certified letter, including your name, contact information, and legal basis for requesting a copy of the trust, including the relevant law entitling you to a copy. It may also be wise to include your right to file a petition with the probate court if the trustee continues to refuse your request.
Some common places to find a missing living trust is first and foremost, ask your drafting attorney. However, if your drafting attorney has passed away, it is the responsibility of their estate trustee to notify California Bar Association if legal documents, including living trusts, have been transferred to another attorney. If you can't find the original living trust document, you can attempt to contact the California Bar Association for some assistance. Trusts are not necessarily recorded anywhere, so you can't go to the county recorder's office or the courthouse to ask for a copy of the trust. However, if a real estate was funded into the trust, a copy of the trust may be recorded in the local office of the county clerk. So that's something maybe perhaps you can double check and request and see if it's a possibility to retrieve a copy of the trust from the county recorder's office.
So it's real important to store your living trusts and estate planning documents in a safe place. When you do an estate plan with us, we usually provide you an electronic copy of your documents. It's a good idea to email it to yourself, so you also have a safe place and you know that it's in the cloud. If your computer dies or if your house burned down, you know it's in your Yahoo or Gmail account or Hotmail account, and you can access that anywhere. Make sure that your spouse, partner, or successor trustee knows the location of your original document. It's a good idea to also send them an email of your estate planning documents. If you're unable to find your documents, your best option is to find a new attorney and revise your estate plan. So this is only available for the actual trust maker, the settlor or grantor of the trust. If you're a beneficiary, you can't just create a new estate plan if you can't find the trust maker's documents. So you can do a trust restatement in which it will be stated that the new terms of the trust supersedes or replaces any prior estate planning documents that you have now misplaced. If you have any other questions about estate planning, or if you wish to need assistance in locating a trust or a will, give us a call and we'll be more than happy to assist. We'll provide a free 20-minute consultation. Until then, please subscribe to our channel and we'll see you in the next one. Thank you.